State's ready.
Defense ready?
Yes, Your Honor.
All right. This is a motion to enter adjudication of guilt. Present are the state through Mr. Andrew Edelman. The defendant is present through video conference, and the defense attorney, Marshall White, is present.
I think we lost her again, Judge.
You're kidding.
No. Ms. Gaines, can you hear us?
She's telling me it just keeps kicking her out. The video, I think the video part of it is kicking her out.
Your Honor, in the meantime, may I be excused for a few minutes?
As you may. Hurry. Hoo, hoo, hoo.
Did I miss anything?
Not at all. It is now 1:50.
I just asked you to call back in, Judge.
She's coming, coming back on now, Judge.
Mrs. Gaines, can you hear me?
Now I can hear you.
Okay. Well, Judge, she's back on.
All right. Ms. James, I'm going to try and do this without seeing you, although Mr. Marshall White, your attorney, as an officer of the court is assuring me that it is you that is on verbally with us by phone. Is that correct?
Yes, sir.
Marshal White, are you assuring the court that it is Ms. Gaines that is on with us?
Yes, that sounds like her voice, as well as the number matches the number I have for her in my phone.
Let's try and proceed. Do you have any objection to proceeding without her visibly being seen, Mr. White?
No, I do not, Your Honor.
How about you, Mr. Edelman? Any objection?
No, sir.
And we're going to waive her video appearance, but she is present with us by phone. Ms. Gaines, would you raise your right hand? Do you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth?
Yes, Judge.
All right. Thank you, ma'am. If you still have your hand up, you can put it down. Ms. Gaines, there's several rights that I need to discuss with you briefly before we continue. The first basic right in this proceeding is the right to remain silent. That means you don't have to make a statement. You don't have to answer questions. You don't have to submit any written documents that have your signature, especially documents that may admit or confess to wrongdoing. Do you understand you have the right to remain silent?
Yes, sir.
Are you willing to give up that right and proceed to enter a plea and then testify?
No, sir.
All right. Then, Mr. White, that means we're not going to proceed at this time. So,
But I'm not sure I'm not too sure she understood your question, Your Honor.
well, I explained that she had the right to remain silent. She says she's not willing to give up that right. I don't blame her. It's absolutely her right. I explained she does not have to make any statements, does not have to answer questions, and does not have to submit any paperwork that has a signature, especially if it would admit or confess to wrongdoing. Those are the rights involved in the right to remain silent. I asked her if she's willing to give those up in this proceeding at this time. She says no. That is her right.
So, I do apologize about that. I didn't understand the question.
Okay. Well, you want to tell me what your answer is and explain what your answer is?
It is yes, sir. I'm sorry.
So you are willing to give up the right to remain silent?
Yes, sir.
All right. Now, don't misunderstand me. That's if your attorney calls you to testify. To enter a plea, you don't give up the right to remain silent. Now, you also have the right to have this hearing in the courtroom, a public courtroom. Because of the COVID pandemic, we're not having open hearings in the courtroom for the protection and health and safety of yourself, everyone involved in the process. Now, do you agree and consent to us proceeding in this matter by video conference, including in your case, audio only?
Yes, sir.
Okay. There's also a right by the state. They have the right to demand that this hearing be held in a public courtroom. Mr. Edelman, does the state consent to having this hearing by video conference?
The state consents to having this hearing by video conference.
Thank you, sir. There's another right that's involved in this matter. When you entered your plea on February 26th of 20, at that time, you apparently had a plea bargain. I'm trying to type in here while I'm talking to you. I'll see how well I did in a moment. Nope. All right. When you entered that plea, it was a plea bargain, and you were told that because it was a plea bargain, as part of the deal, you were giving up your right to appeal. Today, you have a limited right of appeal. That limited right of appeal is that you have the right to appeal this particular hearing and the results of the hearing, but you do not have the right to appeal the original plea that you entered. Do you understand that?
Yes, sir.
All right. True, the charges that you violated the deferred adjudication. It is my understanding that you will plead not true. Is that?
Judge, if I may,
Yes.
Judge, if I may interject, I think Ms. Gaines is intending to enter true on some of them and not true on others. So it's not a blanket true or not true on all of them.
Okay, I'm not understanding what you just said, Mr. White.
What I said, what I said, Your Honor, I think Mrs. Gaines' intention to enter true on some of them or one of them, and not true on some of them or one of them.
All right. Would you tell me what she is going to plead true to?
I think that's probably what, you know, we can go through the violations and Ms. Gaines can enter her pleading.
All right. Mr. Edelman, would you read?
Your Honor, respectfully, Your Honor, I'm not too sure what we have going on here with all these witnesses. Are these witnesses, all these people, are they here for this proceeding here?
Apparently.
Yes.
Okay, so if they are, I want to invoke the rule whenever that's applicable to be applied and with respect to these people on the call here.
All right. How many are witnesses? Would you raise your hand where I can see it?
Well, Your Honor, unfortunately, Ms. Benson-Lemaine has her video off, so you would not be able to see her raising her right hand.
Who is this?
Fatima Benson-Lemaine.
I could see her a moment ago. Okay, or maybe it's just her name. All
I
right.
can come back. I can call back on video if I need to as well.
Well, please do so.
Okay, thank you.
No one else raised their hand, so no one else is testifying on behalf of the state?
Mr. Edelman, would you identify who witnesses will be for the state?
Angela Ashby, Detective Matthew Porter, and Fatima Ben-Slamane, who is in the process of logging out and then logging back in.
All
Why
right.
is she logging back in? I'm not sure.
So that she can be present by video so that the judge can see her.
Okay.
All right. Detective Porter, Ms. Ashby, and Ms. Benson. Is that who it was?
Ben-Slamane, sir.
Oh, pardon me.
If I'm pronouncing that correctly, and I'm not certain that I am.
Is Ms. Luna going to be offering evidence in this matter as well, Your Honor?
Who?
Ms. Luna.
I don't know just yet. Maricela Luna, are you going to testify or offer evidence?
Not that I'm aware of, Your Honor. Angela Porter is here. I'm sorry, Angela Ashby is here to talk about anything that Andrew may have questions on. If there's a question that needs to be answered and Angela needs
All right.
help on, I will help her.
So that means you're not going to be a witness.
Unless Andrew asks me, not that I'm aware of, no.
Mr. Edelman, is there a chance that Ms. Luna might be a witness?
There's a chance, but I never intended on calling her as a witness. I was going to rely entirely on Ms. Ashby. Now, Mr. White might call her. I don't know, but I didn't intend on calling her to testify to anything.
All right, Mr. White, do you intend
Yep.
to call, or is there a possibility that Ms. Luna may be a witness?
Well, it seems to me that she has not been entirely ruled out by either side here. So I would ask the court to apply the rule to Ms. Luna.
All right, I have no problem with that. All right, so we have Ms. Ashby, Detective Porter, and Fatima Ben-Slamane,
Yes.
and Ms. Luna. Would you all raise your right hands where I can see them? Let's see, 1, 2, 3, 4, I believe. Okay. Do each of you solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right,
Yes,
you
Your
may
Honor.
put your hands down. The rule of witnesses has been invoked. I'm sure each one of you is aware of it, but I will remind you. That rule requires that you step away from the proceedings in this matter. In this case, you will have to, Patricia, you're gonna have to help me here. This is,
I'm gonna put them in a breakout room, Judge.
all right.
Breakout room 1.
You will each be placed in a breakout room. You may be put together. However, be aware that the rule of witnesses means that you cannot in any form or fashion communicate with each other concerning this matter. Now, if you want to chat and have fun talking, whatever, that's fine. But you have to understand the rule requires that you cannot discuss your testimony or any facts involved in this proceeding. Is that clear, Detective Porter?
Yes, sir.
Ms. Benz-Lemaine,
Yes, sir.
Ms. Ashby,
Yes, sir.
and Ms. Luna?
Yes, Your Honor.
All right. Patty, place them in breakout, please.
It's breakout room 1.
All right. Ms. Luna's still there. Okey doke. This proceeding is on YouTube. It is public. Now, Mr. White, you indicated that Ms. Gaines would be pleading true to some and possibly not true to others. Can you specify, or do you want me to have Mr. Edelman recite each one individually and see what she pleads to?
I'd like to have Mr. Edelman recite anyone individually and see which one she pleads to.
All right. Mr. Edelman, if you would carefully identify each of the allegations in this matter.
Yes, sir. Violated condition number 3 on or about the 9th day of October 2020 in Bexar County, Texas. The defendant, Ivanisha LaShawn Gaines, did then and there associate with Kenton Hayes, a person of harmful or disreputable character, in that said person is a known gang member.
To that allegation, Ms. Gaines, what will be your plea, true or not true? Ms.
Ms. Gaines,
Gaines,
did you hear?
That is true.
you're pleading true.
Yes, sir.
All right. Next, Mr. Edelman.
On or about the 9th day of October 2020 in Bexar County, Texas, the defendant, Ivanisha LaShawn Gaines, failed to report a change of address to the supervision officer within 48 hours.
Ms. Gaines, how do you plead to that?
That was true.
All right. Mr. Edelman.
Violated condition number 1 on or about the 6th day of December 2020 in Bexar County, Texas, the defendant, Ivanisha LaShawn Gaines, committed the offense of possession of marijuana.
Ms. Gaines, what will be your plea to that?
Not true.
All right. Mr. Edelman.
Violated condition number 2 on or about the 9th day of November 2020 in Bexar County, Texas, the defendant, Ivanisha LaShawn Gaines, did then and there fail to submit to drug testing as directed by the supervision officer.
Ms. Gaines, your plea.
Not true.
Mr. Edelman.
Violated condition number 14 on or about the 9th day of December 2020 in Bear County, Texas. The defendant, Ivanisha LaShawn Gaines, did then and there fail to complete 70 hours of community service restitution.
Not true.
Mr. Edelman.
The last alleged violation is of condition number 20 on or about the 9th day of November 2020 in Bear County, Texas. The defendant, Ivanisha LaShawn Gaines, did then and there fail to comply with the rules, regulations, or instructions of portable alcohol monitoring device, in that the defendant failed to have the device serviced, causing it to go into service lockout.
Not true.
All right. Anything further, Mr. Edelman?
No, sir.
So for the record, I see that there are 6 alleged violations. The defendant is pleading true to 2 of them and not true to 4 of them. The two she is pleading true to are a violation of condition number 3 on 9 October 20. She associated with a inappropriate person described as a in the allegations and known to be a gang member is the essence of the violation. Number 2 is a violation for failing to report the change of address within 48 hours. Is that what I heard?
Yes, sir.
Did she eventually report the change of address, or was it just not done, period?
It was reported, just not in the time frame.
All right. And that's condition number what again?
9A.
9A. And then the rest of them are violation of condition number 1, alleging possession of marijuana. All of these alleged to have occurred in Bear County. The alleged possession is 6 December 20. Violation number 2, failed to submit to a drug test as ordered. That's alleged to have been November the 9th of 20. Violation number 14, 9 December 20 in Bear County. Failed to complete 70 hours of community service. And number 6 is violation number 20, 9 November 20 in Bear County. Violation of the rules on the use and maintenance of the PAM, the portable alcohol monitor. All right, State, it is your burden. Call your witness.
Well, first of all, Your Honor, I'd like to excuse Ms. Ben-Slimane and Detective Porter. Their testimony is no longer necessary.
All right. Patty, bring them 2 in, please.
Yes, sir.
All right. Ms. Ben-Slimane and Detective Porter, I am informed by the state that they will not need you for testimony. I intend to excuse you. However, Mr. White, do you have any objection to them being excused since the state says they don't need their testimony?
Not at all, Your Honor.
All right.
Hope they have a good day.
Okay.
Thank you.
Ms.
Have a great day.
Okay, ma'am. And Detective, you're both released. You're excused for the rest of the day.
Thank you.
Be safe, both
Thank
of you and your families.
Likewise.
Thank you.
All right. Mr. Edelman, proceed.
State calls Angela Ashby.
ASHBY. Ms. Ashby,
Yes, sir.
you've been sworn a while ago. You understand that?
Yes, sir.
All right, would you identify yourself for the record by name and how you're employed and how long you have been so employed?
Yes, Judge. My name is Officer Angela Ashby. I've been employed with Bear County Probation for approximately a year and 2 months.
Mr. Edelman?
Ms. Ashby, were you the officer who was originally assigned to supervise Ms. Gaines?
Yes, sir.
So you have supervised her since the beginning of her supervision.
Yes, sir.
Do you have access to a copy of the terms and conditions of her supervision?
Yes, sir, I do. Sorry, I'm sorry. I'm sorry, my light turns off if I don't. But yes,
Mine
sir.
does the same thing.
Okay.
You scared me there, Miss Ashby. I thought you were having some kind of a conniption or other. All right, go ahead.
Yes,
Now,
sir.
Ms. Ashby, on or about the 9th day of November of 2020, did you direct Ms. Gaines to submit to drug testing?
Yes, sir, I did.
And would
I
you
have-
explain to the court the way in which you communicated that direction?
So we meet monthly with the defendants and every 3 months or so often because of just requirements of the courts, we do send our defendants out for drug testing. Ms. Gaines was told to do a drug test on 11/03, which is the office visit. And she had up until the 9th to get it done. And Ms. Gaines did not submit to the drug testing. I have it here in my chronos, which is something that we document to report that we sent our defendants out to do a drug testing. I'm sorry, from 11/03, the defendant was sent to UA. Actually, I have it 24 hours. So she was supposed to do it 11/03, but because I give my dependents sometimes a little bit of extra time. I said, Ms. Gaines said you didn't have it done by this time. You failed to submit to that drug test. But in chronological, and I have it documented that I sent her to a drug test.
Your Honor, Your Honor, I just want to make sure we're clear. Just want to make sure we're clear on the scope of the violation. I think it says November 9th. That's not what she just testified to.
Yes, sir. I told Ms. Gaines on 11/3 that she needed to submit to a drug test. And Ms. Gaines failed to submit to a drug test.
Did you just say 24 hours though?
Yes, I did say in my chronos, I did say the defendant, I would give a defendant 24 hours. Coming back and talking to Ms. Gaines a week later, she still had not submitted to that drug test. So I documented that on that 9th that she had failed to submit.
Proceed,
Okay.
Mr. Edelman.
Thank you. Now, officer, would you briefly review condition number 14?
Would you like me to read it? I'm sorry.
Please.
Yes, sir. Perform 70 hours of community service restitution and provide proof as directed by the court at the rate of 23 hours per month. You will fully comply with all the rules and regulations and instructions as directed by the head or authorized personnel of that agency.
So if I understood that correctly, it means that Ms. Gaines was required to provide proof of completion of 23 hours of community service per month until she had completed 70 hours. Is that correct?
Yes, sir.
Has she provided proof of completion of any community service hours?
No, sir.
Now, on or about the 9th day of November, did you receive any notification from the vendor of the portable alcohol monitoring device?
Yes, sir. I received.
Wait.
I'm sorry.
You answered the question. Let me wait until I ask the next one, please.
Okay.
Now, did you receive notification that the device had been serviced as required?
I received documentation on 10/05 that she got the she got the device installed.
Or did you receive
Or
any further documentation indicating that the device had been serviced?
no, sir.
The device go into lockout on or about the 9th day of November 2020.
Yes, sir.
Did that indicate to you that the device had not been serviced properly?
Yes, sir.
Pass the witness.
Okay, Ms. Ashby. Now, on November 9th, 2020, you're indicating that Ms. Gaines was supposed to have indicated to you or informed you that she was supposed to submit to a drug test?
Yes, sir.
Or is it November 9th, or was she supposed to tell you by November 4th that she had submitted to a drug test? Which one is it?
She's supposed to tell, she's really, the defendant doesn't have to necessarily come back and state. She's supposed to go submit to a drug test, and I can go to the system myself and look to see if she submitted to a drug test. With the week next coming to go, look at to see if she submitted to a drug test, I saw that she had not submitted to that drug test.
Okay, yeah, I want to just make sure you understand my question.
Mhm.
Now, your instructions to her were to get the drug test done within 24 hours, or your instructions to get the drug test done anytime she wanted to?
My instructions.
What were your instructions?
There were 24 hours. It was supposed to be 24 hours. Yes, sir.
Okay, so she was supposed to get the, and how did you communicate those instructions to her?
Verbally.
Verbally?
Yes, sir.
Is that normally how it's done when you actually I guess your client or the defendant, probationer, to do the drug test?
Yes, sir.
Now, COVID restrictions didn't have anything to do with this?
No, COVID restrictions were lifted back in probably May of 2020.
May of 2020? Okay. Now, I think it's your testimony that Ms. Gaines did not provide you any documentation whatsoever. Well, let me say this. So let's kind of take a dive into the COVID restrictions as they affect the I guess the completion of the probation terms. How did the COVID restrictions apply to Ms. Gaines completing her community supervision restitution before May?
Ms. Gaines has the opportunity to.
I mean, how did the COVID restrictions apply in general to completing community supervision?
Say, for instance, if they could not do volunteer work or do community service, many of the judges allow clients to or defendants to donate towards community service. If they cannot work those hours physically, they allow to donate towards those hours. Some judges.
I think you're missing my question. I'm talking about the COVID restrictions. How did the you just testified that the COVID restrictions were lifted in May.
Okay, so the COVID restrictions, for a time being, the courts kind of just shut down, and they stopped drug testing or any type of, I guess, community service for, community service wasn't really added that. I guess I'm just sticking that under the umbrella, but the courts were saying, no drug testing for up until this time because of COVID-19. So up until pretty much May of last year, the courts wouldn't allow or didn't want people to go drug testing because of COVID-19. Yes.
No, I understand that. I'm talking about the community supervision part of that restriction.
From my knowledge, there's not a specific, community vision, okay, we'll just, when you have the time or whatever, we'll just pick it back up when we can. But there's other ways to do community service other than work those hours.
So it was the probation department that expectation that Ms. Gaines was to go out into the community and complete, how many hours did you say she committed to completing per month?
23 hours per month.
So it was probation's expectation that Ms. Gaines was supposed to go out into the community during a raging pandemic and complete 23 hours of community supervision?
I'm sorry, what's your last name, Mr.? I just want to call you correctly. Ms. Gaines has had, I understand between those times, March and May of last year, COVID-19 was really hitting the population kind of hard, and everybody kind of just stopped for a little bit. But that's, January, February, March, April, May. We're talking about maybe June, July, August, September, October, November, December. There's ample time for Ms. Gaines to have completed even a portion of those community service hours.
Yeah, I understand. Do you know whether or not Ms. Gaines is pregnant?
Yes, I am aware of that.
So you are aware that Ms. Gaines is pregnant?
I'm aware of that, yes, sir.
How many months are you aware that she's pregnant?
I am not aware of how many months. I know that she told me maybe, I think maybe 3 months. I mean, maybe she told me around December that she was pregnant.
Okay, all right. I'm sorry?
I'm sorry, I'm just trying to think when she told me she was pregnant.
Okay. Now, with respect to the portable monitoring device, the PAM device, all of these violations occurred on November 9th, the ones we're discussing. Ms. Gaines had the device installed. She just didn't have it properly serviced. Is that what the violation? Is that how you see it?
From my perspective, she got the device, she obtained the device 10:05, and she was supposed to recalibrate the device 11:09. When she did not recalibrate the device, I was sent a lockout notification stating that Ms. Gaines was locked out of the device. However, I did contact the vendors and talk to them about this case.
And what did they tell you?
The vendors stated that Ms. Gaines got the device, and in the very beginning, she was having some issues. Ms. Gaines sent back the device. They sent her her brand new device, and Ms. Gaines failed to activate the device. And they've contacted her multiple times about the device, and that she didn't calibrate the device 11/9, and she hasn't gotten into contact with them about the device.
Okay. So from 10:05, I'm a little confused. Is that what you're saying? She actually had two different devices. One of them didn't work, and they sent her a new one.
Yes, sir.
Did the second one work according to your
According to
documentation?
To be honest, I'm not aware of that. I don't want to say yes because the information that I got was they sent her a brand new device and she failed to activate it. That's what I was told. And so because she didn't activate the device on that date that she was supposed to calibrate it, it locked her out. I was sent a lockout notice, and she has failed to return the device and tell them about the device. So of course, I think she's getting, from what I know from the lady, that she is getting, they're either she's in collections for the device because they still have the device on their reports or whatever, because she has not returned that other device, or she has not gotten into contact with them.
Okay, all right. Now you were passed over to me, and from my understanding here, it looks like you are the only witness for the state. So far, Ms. Lunam, I guess, hasn't been excused. But I didn't hear you testify about any possession of marijuana.
Yes, sir. Well, the possession of marijuana comes from a arrest that she had on 12/09, where she was arrested, and I got a report that she was arrested. And any type of new violation that we receive, we have to submit a new MTR on that arrest. So Ms. Gaines was arrested on 12/09, and I believe she was out the next day, but she was still arrested.
I understand. Now, do you know anything with respect to where that charge stands now?
Yes, sir. I believe that charge was cleared.
What does that mean?
It was closed.
How was it closed?
I'm not aware of that. I can go look at, I mean, when I did check, I did see that the possession marijuana charge was closed, but I'm sorry, but before that, we filed charges.
I understand that, ma'am. Let me
Okay.
just, you can get, he'll have a chance to redirect
Mr.
you.
White,
But
Mr. White, do me the courtesy, if you you think the witness is not properly responding, make an objection of non-responsive. Don't try to lecture her or tell her what to do or how to do it, please.
okay, objection, Your Honor, non-responsive.
There you go. Ms. Asby, please listen carefully to what Mr. White asks you and answer only what he asks you. Don't elaborate. Don't try to explain. Just if you have a simple answer, give it, please.
Okay. Yes, sir.
All right.
Okay, Ms. Ashby, was the case dismissed?
Yes, sir. I believe, yes, sir. From what I saw on my system, the case was closed or dismissed.
And what day was it dismissed or closed?
I'm unaware of that right now, sir.
I thought I heard you mention something. You said you looked. What day did you look and see it?
I just knew the date that she got the arrest, sir. I would have to go into my files right now. You want it?
I'm just wondering why it's on this particular motion to adjudicate.
It's on the particular motion to adjudicate because we have to file a motion in 24 hours when we see a new arrest.
No, it's an amendment to the original motion, I believe.
Yes, sir.
So it didn't get re-amended.
No, sir. The first motion to revoke was for the first two charges of the number 3 and number 9. When she got arrested on 12/09, another motion to revoke, the first amended, was added on to her first motion to revoke.
Right. Yeah. We're on the same page there. But my issue is, why didn't it get re-amended to take that charge off?
Well, that's a good question.
I'll pass the witness, Your Honor.
Thank you, Mr. White.
Nothing further from the state, sir.
All right. Mr. White.
Your Honor, respectfully, I will call Ms. Gaines.
Ms. Gaines, can you hear us?
Yes, sir. I can hear you.
All right. Mr. White has questions for you, ma'am.
Thank you, Your Honor.
Yes.
Ms. Gaines, how are you employed?
Right now, full time,
And who do you work for?
Wells Fargo.
And are you working from home?
Yes, sir.
And how long have you been working from home?
Since April of 2020.
Ms. Gaines, do you have any children?
Not
Your
yet,
Honor,
no, sir.
I object to this line of questioning. It doesn't seem to have any relevance to any matter at issue for these proceedings.
This time I'll overrule that. Just a little bit of background on who she is and what she's doing.
Yes,
Thank
sir.
you, Your Honor. Ms. Gaines, at this time, you don't have any, you are pregnant?
Yes, sir.
How many months pregnant are you, Ms. Gaines?
I'm 6 now.
6 months pregnant?
Yes, sir.
So by my math, that would make conception around October.
Yes, sir. And previously, before I lost my son, September 14th.
You had a miscarriage?
Yes, sir.
So Ms. Gaines, okay. That means you've been continuously almost pregnant for about, well, how long, how far along were you before you miscarried?
5 months.
5 months?
Yes, sir.
So that would make conception around April 2020?
Yes, sir.
So you've been pregnant almost continuously for a year?
Yes, sir. It'll be 14 months in July.
Okay, Ms. Gaines, I mean, this is obviously pretty personal, but who is the alleged father?
Kenton Haynes.
Now, and this is an individual that you're alleged to have been involved with, who has, I suppose, a gang background.
Yes. Yes, sir.
Did you say Hayes or Haynes?
It's Haynes, but on documents they spelled it Hayes.
What is his name?
Kenton Haynes, Haynes.
Haynes.
Yes, sir.
Now, how long have you known Mr. Haynes?
Over 3 years now.
So you knew Mr. Haynes before you went on probation?
Yes, sir.
Are you guys married?
No, sir. Engaged.
Engaged?
Yes, sir.
Okay, I'm gonna move on to community service condition where you had to complete 70 hours of community service, Ms. Gaines. Have you completed any community service?
No, sir.
And why is that?
Last year when I was first given my everything that needed to be completed, I only was able to complete the things that were open at that time, which I completed the DWI panel course and another course, which I turned in certification. And then we couldn't physically do the community service due to COVID regulations. So I didn't have an extension date, but I didn't have another date, a deadline at all. After I informed there were no community service due to being pregnant and also COVID restrictions, there was no one accepting. I wasn't provided any additional things that can be commuted for that, but everything else was complete.
I see. Okay, Ms. Gaines, I want to move on to the portable alcohol monitoring device. You heard Ms. Ashby testify. What were the circumstances with respect to this this PAM? We'll just call it PAM for short, portable alcohol monitoring device. What she testified that you got one and it was broken and you sent it back. What are the circumstances here?
So the PAM, that was actually the handheld. That was the device for the car. First, it was the car, but I mentioned with my license being suspended, I didn't have a car anymore. I Ubered and Lyfted. So then we went ahead to the one that I had to take home. I purchased the first one. They charged me $100. I got it. It became, it didn't work. So I sent it back to them. They sent me a new one, which didn't work. I still have multiple emails trying to reach out to them. I still also have my bank statements where they're charging me monthly, and I've been trying to contact them by phone and email to let them know they're charging me $100 monthly with a defective item. And that was my second to third time speaking with them about a defective item. The third time, they didn't correct pieces.
So let me just make sure I'm clear. So is it your testimony that you believe you've been provided 2 defective devices?
Yes, sir.
Ms. Gaines, are you drinking?
No, sir.
Ms. Gaines, you heard Ms. Ashby say that the marijuana case was closed out. Was it closed out and dismissed?
Yes, sir. It was dropped, I believe, the 13th. I was arrested the 9th, and then the 13th it was dropped. I called the court. They said due to no evidence or lack of evidence.
So is that what you're saying is 3 days later?
Yes, sir. 4 days.
4 days, my
Sorry.
bad. 4 days. So 4 days later, after you were arrested, 4 days later, the case was dismissed?
Yes, sir.
Okay, Ms. Gaines. Why do you think the court should keep you on probation and not enter adjudication of guilt?
Can you repeat that question? I'm sorry. Kind
Why
of
do you
went
think-
in and out.
Why do you think the court should keep you on probation and not enter an adjudication of guilt?
Due to all the violations, they're incorrect or either have something reasonable that I have to live with. It's just my life, my current life that I have to deal with a violation. That's my child's father. The other violations, not being provided credible information or facts. This is my first time ever in my life going to jail. I have to be told things. When I reach out, there's no communication. It's no excuse, but it's my first time. It's not a walk in the park, but I'm not provided enough information or anything.
Are you going to have a problem complying with the terms and conditions of probation that you've already signed?
No, sir.
I'll pass the witness, Your Honor.
Edelman, anything else?
Few questions, sir.
All right.
Ms. Gaines, is it your testimony that you asked your supervision officer, Ms. Ashby, for alternatives to your community supervision and she didn't give you any?
Yes. Well, let me fix that. We both discussed the time frame for community supervision, but we also discussed me being pregnant, and there was no where to do the community supervision due to regulations. Nothing else additional was provided. For example, something else to substitute with those hours, nor was a date given.
And it's your testimony that you asked for alternatives and didn't receive them. Is that correct?
I did not ask. I did mention why I'm not able to complete what was provided to me, but I didn't know any additional. Like I mentioned, this was my first time. I just let her know, hey, this is what's provided for me. This is what I'm able to do, what they're not providing, but nothing else was provided to me as far as the alternative. I didn't know there was an alternative. I was just doing what I was supposed to do.
And you were aware that condition number 3 of your supervision requires you to refrain from associating with persons of harmful or disreputable character?
Correct. I am aware of that. But that is my child's father and my fiance, which I've been with since before.
Objection,
probation.
non-responsive.
Ms. Gaines, did you hear the question?
Yes, sir.
I take it your answer is yes, you were aware of the rule.
Yes, sir. I was aware of the rules.
All right.
May I continue, sir?
Yes, you may.
And Ms. Hay and Ms.
For the record, Mr. Edelman, your objection was sustained and I instructed the witness. Proceed.
And Ms. Gaines, you already pleaded true that you violated condition number 3 by associating with a person of harmful or disreputable character, in that the person is a known gang member, did you not?
Yes.
So you're admitting that you know that Mr. Hayes is a gang member, aren't you?
No. It was read allegedly.
You pleaded true to the violation of the condition, all of it. Are you now saying that you wish to withdraw your plea and change it to not true?
No, when the condition was read, it said allegedly a gang member.
Your Honor, may I read the violation condition to the court?
You may.
On or about the 9th day of October 2020 in Bexar County, Texas, the defendant, Ivanisha LaShawn Gaines, did then and there associate with Kenton Hayes, a person of harmful or disreputable character, in that said person is a known gang member. That's what you pled true to, Ms. Gaines, isn't it?
Yes.
Thank you. Nothing further.
Mr. White, anything else?
Yes, brief redirect. Your Honor, respectfully, I think the violation is very nuanced. I think Ms. Gaines, you did associate with Mr. Kenton Haynes, right? Correct?
Yes, sir.
Okay. Now the issue I think turns on whether or not you knew he was you're basically admitting to knowing that he was a gang member. And now the issue is, go ahead.
On that part, no.
Okay. All right. So I don't think she's trying to pull one over the court's head, Your Honor. I think she's admitting to associating with Kenton Haynes with respect to that violation. Miss
Was
Gaines.
that a question, Mr. White?
I'm sorry?
Was that a question, Mr. White, or was that a little bit of explanatory?
I think there was a little bit of clarification about the violation because it just seemed he went back over and read it again, Your Honor, after she had already entered her plea.
Which was already noted by the court that she pled true.
Yeah, but he went back over it as if it needed to be clarified, and I want to re-clarify what he was trying to do.
Okay, Mr. White. Anything else?
Yes, Your Honor. Real briefly. Miss Gaines, with respect to reporting one issue that I think the court had already kind of gotten a response from you, or released a response about the change of address. But you didn't report the change of address within 48 hours. How long did it take you to report the change of address?
Honestly, I don't remember the exact date, but I just know it wasn't within the 24 to 48 hours.
Okay. And what were the circumstances that caused you to have a change of address?
It was a temp location at the time. Due to my grandma being sick, I couldn't be able to be around her. So it was technically supposed to be a temp location at the time. When you do a process of apartment complex, you don't know your approval within 24 to 48 hours. So I didn't report it. I don't remember the exact time, but not within 48 hours.
Okay. Your Honor, I'll pass the witness.
Mr. Edelman, anything further?
Yes, sir. Patty, would you please enable screen sharing for me? Thank you.
Welcome.
Ms. Gaines, can you see the document displayed on the screen?
No, sir.
I don't think she has any video capability.
Ms. Gaines, is that correct?
Yes, sir.
Ms. Gaines, you signed a lease with Boulder Creek Apartment Associates, did you not?
Yes, sir.
For 0632, apartment number 0632 at the address of 12330 Vance Jackson?
Yes, sir.
And the lease term began in March of 2020, correct?
Yes, sir.
And goes until September of 2021, correct?
Yes, sir.
All right, do you still want to characterize this as a temporary move?
Yes.
So March of 2020 through September of 2021 is what you characterize as a temporary move.
That's what I characterize it as, but that was the least that they had available. There's the least term that was available, yes.
I see. Nothing further.
All right. Anything further, Mr. White?
No, Your Honor.
All right. Arguments state.
Your Honor, I'm not particularly impressed by Ms. Gaines's dissembling obfuscation. She knows what the rules are, and she knows that she has to play by them, and she simply hasn't. She knows that she's not allowed to associate with people of disreputable and harmful character, and she does. She knows that she needs to report a change of address within a certain amount of time, and she doesn't. She knows that she needs to complete her community service hours at a certain rate and within a certain time. She hasn't. Not only has she not done that, she has not asked for alternatives in order to do it. She has not made sure to have the portable alcohol monitoring device installed. She failed to submit to drug testing as she was ordered to do. This is the second time that Ms. Gaines has been before the court. Once was to answer for a violation report in which the court admonished her. Now she, I think, has exhausted the well of the court's sympathy and compassion. The benefit that she received for being on community supervision was to avoid a conviction for this offense. She doesn't deserve to get that benefit if she doesn't play by the rules. Plain and simple.
Mr. White.
Yes, Your Honor, respectfully, I would ask the court to deny the state's motion to enter adjudication of guilt. Ms. Gaines is a person who is clearly, I think, responsible. Ms. Gaines is working. She's been working for several years. Ms. Gaines is an expectant mother. She's already lost one child since she's been on probation. God forbid that this probation had played any role with respect to that. And she testified to the court that this is the first time being on probation. There's never a good time, in my opinion, and I've never been on probation, but just speculating, there's never a good time to be on probation, but being on probation during the middle of a raging pandemic, while you're pregnant, you have a miscarriage. Ms. Gaines just went through some personal issues, Judge. And frankly, some of these violations, with respect to Mr. Haynes, she's been in a relationship with Mr. Haynes for several years, well before this probation started. She was pregnant by him, shortly after being put on probation in February 2020. Your Honor, these are not violations of someone who is, I think, irresponsible, who doesn't deserve to have probation, and deserves to have a conviction for this particular charge. And Ms. Ashby even testified, Your Honor, with respect to the portable device, that there were issues. At least one of them got rejected, was broken, and Ms. Gaines testified that the other one was broken. With respect to her change of address, clearly Ms. Gaines has reported a change of address she testified she's reported a change of address. And another thing, Your Honor, I think the state just piled on here with respect to this motion to enter adjudication of guilt. They smeared it. In other words, he's reading, Mr. Ellerman read the possession of marijuana, and he knew full well that case had been dismissed. Or if he didn't, he should have known. It should have never been part of this. They just piled on here. For what reason, I do not understand. I respectfully ask the court to to deny the state's motion to enter adjudication of guilt. Ms. Gaines is a responsible individual. She's out here working. She's trying to do the right thing.
Anything else, Mr. White?
I'm sorry, Your Honor.
Anything else?
No, Your Honor.
All right.
Your Honor,
Ma'am.
is Miss Luna excused, or can I let her go, or she's still in the waiting room?
Since they have argued, now bring her back in if she needs to, since she's the CLO. Ms. Ashby can remain because there will be no further testimony.
You go ahead and let her know, Judge. I had her in a waiting room.
All right, Ms. Luna, you may stick around now. We're through with testimony. We've had argument. If you choose, though, you can be excused. I don't have a problem with that. All right. Ms. Gaines has pled true to a violation of number 3, that is associating with disreputable characters. I understand the circumstances that she's testified to. I'm not overwhelmed by the fact that she is in a relationship with a person that is a relationship that has been in existence since before the adjudication. Number 2, she pled true to also. So there's 2 items that, again, I'm not overwhelmed by them. Nonetheless, I know that I personally talk to people when they're granted a deferred adjudication, and I tell them I expect 100% completion, 100% living up to the conditions. It's interesting that the violation of number 1 by way of arrest for possession of marijuana was dismissed. So that has nothing in my consideration. It adds nothing. Violation number 2, that she failed or refused to submit to a drug test. That I am troubled by, because it leads to a possible conclusion that she did so because she knew she would be dirty. Whether she was dirty or not is not the question. A reminder that deferred adjudication requires 100% compliance, and those terms have been spoken over and over in my courtroom to people that are placed on deferred. The violation of condition number 14, the community service hours. I am troubled that apparently there's none of it been done. 0. And I am aware that we have had COVID that makes it difficult, but I also expect some show of good faith, some effort. So I find that perplexing. The PAM, Ms. Gaines is, to me, obviously an intelligent person. She works at a bank. She speaks well. She knows what she's doing and saying. She had a problem with the PAM, and for months and months just chose to ignore it. She did initially complain, was sent a second device, and then now she testifies that it was also a defective device. If my Fanny can be put in jail if I don't live up to 100% of the conditions, I expect some good faith observance of the rules. I expect some real, honest, and diligent efforts to make sure that I'm doing what I'm supposed to do. If there's questions, then ask the question and get the answers. Ms. Gaines, you worry me. None of these are horrible violations, but the violations are there nonetheless, and it's not the first time. You apparently don't take me at my word when I tell you you must live up to 100% of the conditions. We've got 6 violations alleged. For the most part, they've been proven. Obviously, the POM has no merit since it was dismissed, but everything else has some merit. Now, my problem is, what should we do with you in fairness? And I realize, and I am keeping in mind that the COVID has had a tremendous amount of impact on people and their abilities to live up to the conditions. Mr. Edelman, what is the recommendation of the state?
The recommendation is to adjudicate guilt, not necessarily to revoke supervision, but Ms. Gaines has at this point had multiple warnings that she needs to comply with all of the conditions, and she hasn't. And so I don't think that she deserves to continue to have the benefit of her original plea.
Mr. White.
Your Honor, respectfully, I think the court touched on a couple of things there that I'll just echo. And I said it before, the pandemic, Ms. Gaines has had a miscarriage during this probation, Your Honor. I cannot testify to the effect that that would have on a person, but I know this pandemic has caused a lot of people not to meet their responsibilities in a whole lot of areas, much less probation. Your Honor, respectfully, I recommend that the court deny the state's motion to enter adjudication of guilt and continue Ms. Gaines on the probation, community service probation that she's on, the deferred. Ms. Gaines is trying, she indicated to the court, she testified about completing the other things that she can do. She has not flopped on this probation.
Ms. Ashby?
Yes, sir. Yes, Your Honor.
Do you have a recommendation yourself?
Your Honor, me and my manager, because you had already recommended her for her top evaluation and the treatment that she was already supposed to be getting into, so that's already on her recommendation list. But my supervisor said the GPS device, because of not knowing where she had lived, that's kind of what he had recommended for her. But other than that, there was no other recommendations but to continue her on probation. But
So y'all are not making a recommendation of to enter a finding of guilt?
I agree with the ADA, or what the ADA is going for. But yes, sir, the additional recommendation was the GPS device.
Sorry, say that again?
The additional recommendation was the GPS device.
But just to make clear, you're not necessarily recommending the finding of guilt?
No, sir.
All right. All right, I'm going to type up some stuff here. Ms. Luna, am I allowed to extend the probation?
Yes, Your Honor.
Okay. The court finds that Ms. Gaines has violated conditions 3, 9A, number 2, number 14. Ms. Gaines, you may not deserve it, but I'm going to deny the motion to enter adjudication of guilt. I'm going to extend your probation by 180 days. That's 6 months added to what you had. I'm going to add what's called zero tolerance, ma'am. Zero tolerance. That means if you so much as sneeze out of line, they're going to bring you back in here. And if the evidence in any way supports it, you may find yourself minus the deferred adjudication and with an adjudication of guilt. Do you hear what I'm saying to you, ma'am?
Yes, sir.
Sometimes we don't choose who we love and who we care for. I don't hold against you that you associate with a man who is the father of your baby. The fact that you didn't complete the CSR hours, that angers me, but it doesn't replace my ability to think. The fact that you were told to take a drug test and you refused to, ma'am, I mean, very bluntly, that's enough for me to just go ahead and find you guilty. But I'm not in a hurry to do that. Mr. White has advocated for you quite forcefully. You've done a good job, but I will tell you bluntly, there's not a hell of a lot of reason why I don't find you guilty. It's just that maybe I'm trying to see if we can help you some. You've got a good job apparently with the bank. How long have you been with them?
With them, it's been a year. Before that, I was with USAA Bank.
Both good jobs. Don't make me regret this, ma'am. I will tell you right now, if you violate any other rules and regulations, if you fail to do the CSR or arrange something with it, if you violate anything and the evidence shows it, I'm not the one that's going to be in jail. Are you hearing me?
Yes, sir.
All right. Then that is my ruling. Any questions, Mr. Edelman?
Your Honor, can we make a provision to allow Ms. Gaines to buy off her community service hours if she has the resources available?
I'll expect Mr. White to come to me with such a motion if he chooses to or she chooses to. As of right now, she's got 70 hours to do. If she has limitations of any kind, then I expect a motion for that. My Lord just has a limit, and that limit has been met today. We understand each other, Mr. White?
We certainly do, Your Honor. I understand completely. Your Honor, I just want to clarify, how many months did you extend that probation?
6 months, 180 days.
6 months. Okay,
Yes,
thank
sir.
you.
And zero tolerance, Mr. White. You tell her what I mean by that.
I will, Your Honor.
All right.